Good afternoon, everyone, and welcome to UCL. I'm Ed Poulton. I'm a partner in the dispute resolution team of Baker McKenzie here in London. And it's a great honour and pleasure for me to welcome you all to the 5th annual Baker McKenzie UCL lecture on international law and litigation. It's an event that has gone from strength to strength since Professor Vaughan Lowe gave the introductory lecture in the Middle Temple Hall 5 years ago. And since then, we've had a series of extremely distinguished speakers delivering lectures of the highest caliber, and I'm sure that today will be no exception. From our perspective, Baker McKenzie sponsoring this lecture makes absolute sense. Our disputes practice is the most international, and international law is at the heart of everything that we do. But more fundamentally, international law will remain front and center of political and journalistic analysis of Western states' response to the events in Paris and the refugee crisis. And one person in particular has been instrumental in ensuring that issues of public international law enter the mainstream dialogue on these issues. As well as his prominent role as a professor at UCL and his thriving practice as an arbitrator in investment treaty disputes, and as counsel in international cases before the International Court of Justice, Tribunal for the Law of the Seas, and many other fora, Philippe Sands has played a crucial role in making people aware of issues such as the responsibility of states under international law for the acts they commit. His book, Lawless World, addressed, among other things, the status of the US and UK's intervention in Iraq. In Torture Team, he dissected and wholly discredited the US authorities' attempts to justify the special rendition, incarceration and torture in Guantanamo Bay. When he has raised issues, subsequent disclosures and analysis have often, usually, proved him to be right. And we have him to thank for bringing a lot of these concepts into the mainstream, a Professor Brian Cox of international law, so to speak, albeit without the leather jacket. Anyway, without further ado, I would like to hand over to my good friend Philippe to introduce our distinguished speaker.
Thank you, Ed. Ed and I have worked together with David Fraser, who's here, in putting together this series now over 5 or 6 years. And in looking for our annual lecturer, we've always tried to go for the individual who straddles different worlds. In our experience, that is the kind of person who is able to shed light on the knotty issues of the day. And when it came to identifying this year's lecturer, we were really thrilled to invite and then to have an acceptance from Maître Yves Fortier. I'm not going to go through his hugely lengthy and very distinguished background, but say just a few personal words about what Yves Fortier represents to the world that I occupy. He is someone who has been in legal practice, who has worked as counsel, has worked as arbitrator, has had the highest diplomatic rank for his country at the United Nations, has served as an ad hoc judge at the International Court of Justice, is an enormously distinguished arbitrator, and has public appointments in Canada even today on issues of very great significance and of relevance to the events that Ed talked about from last Friday. But I came across Yves in a different way. I didn't know him 15, 16 years ago when he wrote a separate opinion in a case before the International Court of Justice, in the case of Qatar and Bahrain. And it was a case that was of interest for many reasons, but one of the reasons we only found out about because of his separate opinion. And in setting out a very well-reasoned separate opinion on issues of merit, he prefaced it by indicating that he had a duty as a judge to comment on something that the rest of the court did not wish to address. And that was the circumstances in which, and I'll use my words rather than yours, Yves, very obviously forged documents had been relied upon by a state in prosecuting its case. Now, in the world of public international law, there are things that one does not talk about in polite company. And one of those things is states that misbehave in legal process. We may hear a bit more about that in the course of this lecture. So in reading his separate opinion, I was very struck by the independence and integrity of an ad hoc judge, no doubt much to the displeasure of the permanent judges of the International Court of Justice, who shone some light. A few years later, I came to know Yves, first when I appeared as counsel in a case before him, and then when I sat with him in now more than one case. And in particular, in the first case that I sat with him, there was an issue in those proceedings which came very close to something that he had previously decided. It certainly was not identical, but it was close enough that another kind of person would have taken refuge in what he had decided previously. But having already discovered that Yves Fortier was someone who was extremely cogent and persuasive as a fellow arbitrator, I also learned that he was someone with a very open mind, who was willing to listen to the arguments of his fellow arbitrators, and if necessary, take a different view, a reasoned different view. And that, in my experience, is not a unique matter, but it's not something one sees the whole time. And so I put Yves Fortier in that category, rare category of individuals in the world that I'm a part of absolute independence and integrity, coupled with remarkable intelligence and acuity, never scared to go forward and look to the changes that may be needed in the way in which we think about things. So he has agreed to talk about subjects that are of great interest and which in certain polite company are not talked about in the world of arbitration and litigation and international law. But just before I hand over to him to give the lecture, which I'm hugely looking forward to, and I think we're all hugely looking forward to, it has to be said, as you will hear as he delivers his lecture, is that Yves Fortier is a very real person. He's someone who recognizes that the law is only one part of our lives. One of the things that I was astonished to find out about, and this elevated him even higher up the pantheon of remarkableness, was that when he was a student in a room like this, studying criminal law in Montreal, the bloke who sat next to him was none other than Leonard Cohen, the singer. And that has always reminded me of the world and the worlds that Yves Fortier occupies. Yves, we're completely thrilled to have you with us. With great pleasure, I ask you to welcome Maître Yves Fortier.
Well, I'm very humbled by that generous introduction, Philippe. I've always known that there was something special that attracted you to me, and now I know it's Leonard Cohen. And I do recall a number of occasions in recent years where you have mentioned the admiration that you had for Leonard Cohen, and particularly once you learned that he had studied law for 1 year only, and then he he saw the light and left the Faculty of Law at McGill University. But I'm very humbled by your remarks, Philippe. Coming from you, this is quite a testament, and I'm very grateful. And my thanks to you, Ed, and David, for and all your partners at Baker McKenzie for having your arm twisted by Philippe and extending an invitation to me to deliver the lecture this evening. It's a great honor for me to follow in the footsteps of the Von Lows of this world. What I would like to do in the next 40 minutes or so is to focus broadly on one of the challenges which has been brought about in recent years by the proliferation of international courts and international tribunals. If I may put my remit more proactively, I will attempt to explore how we can foster institutional innovation in international adjudication. In my eyes, the current diversity of courts and tribunals, and particularly the exponential growth of international arbitration, pose an opportunity. And at the same time, it threatens what I see as a long-held fascination of international lawyers, and there are some eminent international lawyers in the room this evening. Our fascination for international courts as a perfect form of dispute settlement. I will refer to this fascination, for those of you who are still wondering where I took my title from, I will refer to this fascination as the oceanic feeling in international adjudication. Now, in some measure here, I admit that I borrow from Professor Koskaniemi, who described the oceanic feeling in international law as the bold proposals made by international lawyers for institutional architectures for the government of the whole world, inspired by altruism, love for one's fellow men, or indeed humanity. Fear not, I'm not going to go in all directions here. In the world of international courts and tribunals, this oceanic feeling finds expression in proposals to create international courts to manage the dispute of states. The Permanent Court of International Justice, the International Court of Justice, the International Criminal Court, the panoply of regional courts, and the numerous failed and often forgotten proposals for international courts are all projects that have placed faith in international courts as the means to further global peace, justice, and the rule of law. Now, this sorry, I'm recovering from a bit of a cold. This oceanic feeling that I speak of may as well be characterized in terms of a progress narrative, an institutional bias for international courts, or a reading of international law as moving from diversity to unity. And I will attempt to shed some light on how this oceanic feeling may determine the institutional development of international adjudication. I will argue here this evening, as well as in a soon-to-be published article with my friend Danielle Litwin, who has done much of the research which led to this paper. I will argue that this oceanic feeling pulls the development of international adjudication towards courts. Benedict Kingsbury has described how courts are a regulative idea, an ideal to strive for. And practically, the oceanic feeling either pushes away dispute resolution mechanisms that move too far away from courts, or it pulls these mechanisms closer to courts so that they may become more, how would I say, court-like. Now, this lecture is not, I stress, is not about advocating one ideal institutional design or a specific dispute settlement mechanism. Rather, my modest behavior this evening is my modest endeavor this evening is to try and grasp a feeling within the community of international lawyers that I believe may shape which institutions are put forward for the settlement of international disputes, how institutions of international adjudication are criticized, how diversity in international adjudication is evaluated, and ultimately, how we choose to reform and innovate the current system of international adjudication. Now, I will focus on the two mechanisms that, in my view, inform most of the recent and past experiences with judicialization. International arbitration, on the one hand, and international courts. Now, these two mechanisms have been the subject of numerous taxonomies, as scholars have, with increasing eagerness, attempted to categorize the ever more complex network of international courts and tribunal. Their categories often draw distinctions between international arbitration and international courts that are normatively charged, and they, in my view, they appear to reflect an inherent preference for international courts. And for the purpose of my lecture, I will distinguish between international courts and international arbitration, using a very simple criterion, often found in the literature: the selection of the decision makers. International courts have standing panels, whereas international arbitration has party or institution-appointed decision makers. Now, in the first part of my lecture, I will attempt to trace the source of this oceanic feeling. First, I will provide a brief historical review of the relationship between the oceanic feeling and international arbitration and international courts. I will then examine the use of domestic analogies to promote international courts. And in the second part of my lecture, I will move on from the past and assess how the oceanic feeling shapes contemporary tensions between international arbitration and international courts, and how it helps explain certain proposals for reforming international adjudication, such as you well know, the European Commission's initiative on the creation of an investment court. Now, over the course of the past century, the campaign for international adjudication has been instilled in various degrees of intensity with an oceanic feeling. But this feeling was not always associated with international courts. As I'm sure you all know, in the late 19th century, the nascent community of international lawyers envisioned an international system without courts. They ardently believed that international arbitration offered the only practical solution to get the world rid of war. And writings on international adjudication during that period often advocated peace through international arbitration. At the conclusion of the First Hague Peace Conference in 1899, when the Permanent Court of Arbitration was created, the great German jurist Lasse Oppenheim proclaimed, and I quote, "Eternal peace is an ideal, and in the very term ideal is involved the conviction of the impossibility of its realization in the present, although it is a duty to aim constantly at such realization. The Permanent Court of Arbitration is an institution that can bring us nearer to such realization than ever could have been hoped." And this was an opinion which was shared far and wide. Peace societies, pacifist associations of all sorts disseminated the idea of peace through arbitration to a very, very wide public. Indeed, in the 1907 edition of the Larousse Dictionary, the word pacifiste was defined as settled by arbitration. Compelling visual evidence of this association can be found in Douglas Strawn's Stained Glass, the evolution of the peace ideal, created for the Great Hall of Justice in the Peace Palace in The Hague. In the final window, titled Peace Achieved, the symbol of arbitration sits next to Bellona dying in the arms of peace. I was reminded of it last week as I was doing an arbitration in the Peace Palace. Now, the First World War put international arbitration's long-held allure to an abrupt end. The system of international arbitration that existed before the war was now perceived as a failure, as it was unable to prevent the great conflict that engulfed Europe in 1914. And at the end of the war, Hans Wieberg declared, and I quote, "The failure of international arbitration in the past has been so fully proved that we can expect nothing from it in the future for the development of international law." Amen. International law was in a state of crisis, and many openly wondered whether international adjudication could ensure peace by providing an alternative to war. The transition from international arbitration to international courts as the world's privileged instrument for peace arose as a source of renewed faith. International law needed to move away from specialized dispute settlement to a universal institution. Dennis Myers, a contemporary of these early 20th century events, explained that, and I quote, "If such a proposal for a permanent international court had been realized, the newly existent court would probably have been the only present battlefield in Europe." Before the war, a 1907 proposal for an international court sought to closely associate itself with arbitration, as the proposal called for the creation of a court of arbitral justice. And after the war, the proposal for a court did away with any reference to arbitration. The drafters stressed that what they wanted to create was a permanent court of international justice. And when the League Assembly decided in 1921 on the establishment of the Permanent Court of International Justice, James Brown Scott exclaimed that we should fall upon our knees and thank God that the hope of ages is in the process of realization. And with the creation of the Permanent International Court of Justice and the perceived failures of international arbitration, courts became intimately associated with the pursuit of peace. Oppenheim's account of the creation of the Permanent Court of Arbitration, and then Scott's similarly worded account for the creation of the Permanent Court of International Justice, evoke just how seamlessly the oceanic feeling transitioned from international arbitration to international courts. Now, during the interwar period, efforts were made to revive international arbitration, but it never regained its pre-war eminence. The oceanic feeling for international courts continued after the creation of the ICJ. And Hirsch Lauterpack wrote that the primary purpose of the International Court lies in its function as one of the instruments for securing peace, insofar as this aim can be achieved through law. And during this period, it was believed that international adjudication's institutional design should be a formal, hierarchical, and centralized system, one made up of permanent judges with general jurisdiction that would serve to promote coherence, the prevention of war, and the development of international law. Now, in contemporary times, we rarely dream of a hierarchical and centralized system of international adjudication. We're more vocal about what some of us see as the mixed success of the PCIJ and the ICJ. And we're almost also less likely to openly speak of international courts as a tool for peace. We rely instead on domestic analogies to craft our international system of international adjudication. And these analogies have contributed to cement the oceanic feeling for international courts well into the 21st century. Now, the rise of domestic analogies is a natural result, as I see it, of the important role of international lawyers and legal networks have played in the promotion of international courts. The American lawyers that led the campaign for a permanent international court at the turn of the 20th century believed that the international community needed a Supreme Court in the image of their own. They attempted to translate their domestic experience, the legal system they were most familiar with, to the international plane. And during the Second Hague Conference in 1907, this influential group of U.S. lawyers had already unsuccessfully attempted to create a permanent international court. And after the failure of 1907, they redoubled their efforts. And the early 20th century saw a tsunami of writing on international adjudication by U.S. lawyers openly advocating the creation of a permanent international court. And to advance their agenda, they articulated a divide between international arbitration and international courts as one between law and politics. Arbitration was more diplomacy than law. I can relate to that. Its decisions, they argued, were reached through political compromise and not legal deliberation. International courts, on the other hand, represented the triumph of legalism over politics. And after the creation of the Permanent Court of International Justice in 1921, Scott proclaimed that its relationship with the Supreme Court of the United States was that of parent to child. Now, I readily acknowledge, and I want to stress it, that the domestic system is a source of many important lessons, and indeed rich experience. For example, important research has been conducted at the domestic level on the institutional factors that determined independence and autonomy in the decision-making of courts. And it is natural and it's even helpful to turn to these studies of domestic institutions, familiar to every lawyer in crafting a system of international adjudication. But it is equally important to recognize the differences between the international and domestic context and the structure of their respective judicial bodies. By relying on domestic analogies, anticipated developments in international adjudication may become aligned with those experienced domestically. International adjudication must develop along a predetermined path, one that sits squarely with the development of domestic courts. I offer as an example the recent rise of international courts with compulsory jurisdiction. This development is often seen as self-evident, positive, one that brings international courts closer to their domestic counterparts. My worry is that analogies of this sort may gamble with the legitimacy of the international system. And any deviation from the domestic experience immediately tests the credibility, the viability, the hardness of the international system as a whole. And analogies of this sort also create incredibly high expectations for international adjudication. And as we know, these expectations have many times in the past been the source of great disappointment. Now, what I've attempted to demonstrate is how international courts became the vessel for the Oceanic feeling after international arbitration lost favor after the First World War. And this feeling was buttressed by international lawyers and legal networks that reasoned in analogies with their own domestic experience. And yet, much of today's literature on international adjudication stresses a discontinuity with this past. A discontinuity with the Oceanic feeling. It sees the post-Cold War multiplication of international courts and tribunals as a paradigm shift, a radical departure from what has been done before. In many ways, that may well be true. But we must also admit that we are all in some ways influenced by the past. After all, are we not trained to argue from precedent? In the words of our friend James Crawford, the brave new world of international dispute settlement turns out to have a great deal of the old world in it too. So we continue to see proposals for international courts. These proposals are construed in terms where their mere creation is a self-evident development of international law. I need refer only to the 2011 proposal for a World Court of Human Rights, or to the recent proposal by the European Commission for an investment court, to Antonio Cassesi's proposed reform of the ICJ. What Cassese found most urgent to criticize about the ICJ was that, and I quote, "it was substantially an arbitral court, a late 19th century institution oriented to unrestricted respect for outmoded conceptions of state sovereignty." And from this diagnosis, Cassese's conclusions are self-evident. The institution should be transformed into, and I quote, "a proper court of law," with all the attributes and trappings of a modern judicial body. Now, these proposals appear to be made without any acknowledgement of the contemporary success of international arbitration and the ability it has had to influence and bend states to a system of international general principles. And this contrasts with the middling success of several international courts, I suggest, with far more ambitious agendas. Now, take UNCLOS. Although it has wide state party membership, states over the year have seldom resorted to proceedings before the International Tribunal for the Law of the Sea. There is no denying, my friends, that the success of international arbitration has been limited in some measure to international economic law, where it is actively championed. But this should not in any way prevent experiments with the practice in other areas of international law. It is true that international arbitration, in the words of Jose Alvarez, falls short, sometimes dramatically short, of the ideal of a court. And yet, I ask, why should this prevent us from acknowledging its effectiveness, or from using relevant aspects of institutional design towards the development and strengthening of international law in other areas? We should advocate for diversity. We should, instead of searching for the appearance of coherence in international courts. And currently, the pull of the Oceanic feeling narrows the possibility that, equal to international courts, international arbitration may come to contribute positively to the development of international law and the public good. And much of this, in my view, can be explained through what some argue are the functions of international adjudication. In the first UCL Baker McKenzie lecture, my predecessor, Vaughan Lowe, proceeded to describe the function of international adjudication. As some of you will recall, I'm sure, in his speech and subsequent article on the subject, Vaughan suggests that international adjudication has a backward or private and a prospective or public effect. And the former, according to Vaughan, is international litigation's role in the settlement of disputes between parties. The latter is its role in dictating principles that may be applicable in future dispute. Well, the intensity of the belief in the prospective effect of international adjudication, or as I read it, the belief in the ability of an institution to promote social goals such as peace, rule of law, justice, has much to do with the intensity of the Oceanic feeling for international courts. The more intense the feeling, the more institutions and adjudicators will see themselves as catering to the interests of the international community. as working for the benefit of humanity. But absent this oceanic feeling, expectations held by decision makers, international lawyers, civil society as a whole simply wane. International courts wrestling with this oceanic feeling function with the assumption that they positively contribute, at least in some measure, to the public function of international litigation, even if their effectiveness has been the source of much debate. Taking Vaughan's framework, international arbitration is commonly thought of as working exclusively for the backward function, for the benefit of the parties, whereas international courts are thought of as contributing to the prospective function in support of the world community. And this creates an institutional hierarchy that views the international court as the only form of true judicial settlement. Let me illustrate briefly this divide with two examples from opposite ends of the literature, then followed by practical example. In my first example, I refer to the introductory chapter of the Oxford Handbook on International Adjudication and its delineation between international courts and arbitration. The authors explain that adjudicators in courts are chosen by a mechanism that does not depend on the will of the parties. And this means to the authors that the judge's authority derives from a public mandate. And the outcome, you've guessed it, is in essence a public good. In contrast, since the parties select the members of arbitral bodies, the mandate of arbitrators is circumscribed to administering private justice. My second example, I refer to Eric Posner and John Yu's distinction between independent and dependent international tribunals as revealing of a public and private divide. According to Posner and Yu, independent courts are permanent and staffed by judges with fixed terms and provide some form of compulsory jurisdiction. And for this reason, they impose rules on states and constrain sovereignty. But on the other hand, the dependent courts are those with appointed adjudicators, whose aim is to resolve particular disputes. They have limited jurisdiction and a procedure really geared towards users. And this is alleged to express deference to state sovereignty, to speak to the particular, to the exclusive interest of the parties. According to these two constructions, if we side with international arbitration, then we risk being accused of foregoing certain aspirations, of denying the universal and the dreams of working for the benefit of the world community. And according to this view, international adjudication becomes a binary choice between, on the one hand, international courts and universalism, peace and justice, and on the other hand, international arbitration and particularism and privatized justice. Well, when we hear contemporaries discussing the need for a permanent court or an appellate body for investment arbitration, we hear echoes of the belief that international courts are the most effective institutions for the world community. Now, this leaves little room for internal reforms for the current system. The Oceanic ideal type, the court, and its constituent elements are immediately put forward as a necessary reform. I take as an example the European Commission's proposal for an investment court in the context of the transatlantic trade and investment partnership. The mere fact of creating a court is equated with addressing the institution's shortcomings and assuaging the public opposition that has plagued the treaty's long, drawn-out negotiations. And the Commission's first proposal required that only domestically qualified judges sit on the court, an overt reliance on domestic analogies. Its final proposal adds the possibility for jurists of recognized competence to sit on the court. Yet it still preserves the first category, that of individuals who possess the qualifications required in their respective countries for appointment to judicial office. Now, in order to move beyond the traditional associations with the public and private function, we need to accept that the presence of the Oceanic feeling does not make international courts, in all circumstances, better able to work for the benefit of the world community. In a recent book on the International Court of Justice, Glider Hernandez convincingly demonstrated the court's very limited understanding of the international community, la communauté internationale. In fact, international arbitration or any other system of international adjudication could contribute, I submit, to forging a third way, one that brings a new culture of cooperation and that more effectively serves justice in specific disputes while preserving the prospective or public function of international law. The way international arbitration has come to represent one of the few effective international instruments to condemn transnational corruption, as I developed in my Kaplan lecture last year in Hong Kong, is one example where a mechanism serves both the parties and the international community, working for both the public and the private function. Alternatively, the solution may involve, in some cases, relying on domestic courts. Jose Alvarez explained that, and I quote, "As the world learned when Israel put Eichmann on trial, or French courts dealt with Barbie, or South Africa dealt with its own history through its Truth and Reconciliation Commission, local justice through localized proceedings has values of its own." We also, my friends, we also need to work on the expectations we hold about international arbitration and international courts. Currently, the ICJ is Oceanic, as it is expected to speak to the public function because it is an international court. Conversely, the PCA, for example, the Permanent Court of Arbitration, an arbitral institution, is expected to cater to private interests. And the PCA is rightfully criticized when it does so nearly exclusively. The practical effects of these expectations were seen recently in the arbitration between Croatia and Slovenia, which my friend Philippe Sands knows well, conducted under the auspices of the PCA. As we all know, it was revealed in that case that the arbitrator of Slovenian nationality was secretly in contact with a Slovenian agent, which included discussions on how to influence the other arbitrators. And when this information became public, the Slovenian arbitrator resigned, and Slovenia chose the president of the ICJ, the appointing authority, as a replacement arbitrator. Subsequently, Croatia withdrew from the arbitration, as both the Croatian arbitrator and the president of the ICJ resigned, evoking the breakdown of confidence between the parties. Now, in my view, the self-evident and Oceanic reaction to this scandal would be to recommend some improvement that would move the PCA and international arbitration towards an arbitration court, maybe along the lines of the European Commission's investment court. And from this perspective, the focus would be squarely on the arbitral tribunal and not on the institution that administers the dispute. But if, however, trying to be logical with myself, if, however, public expectations were placed on the institution itself, in this case the PCA, the parties would have had more confidence, I submit, in its ability to continue ensuring fair proceedings despite the breakdown at the level of the tribunal. Parties focus on the tribunal and its role in resolving their dispute, and they forget about the institutional guardian of the dispute. And this leaves institutions that administer disputes, such as the PCA or ICSID, with few responsibilities and accountability to the international community. As I near the end of my lecture, I note that a number of internal responses have been put forward to reconceptualize international arbitration as working alongside the public spectrum. Now, these responses are constructive as they move beyond reforms and that continue to advocate international courts as the only path for reform. Internal responses have, for instance, conceptualized international arbitration as a tool of international governance. According to proponents of global administrative law, investment arbitration is engaged in the public regulation of states. And from this perspective, international adjudication is equally about applying international law and resolving disputes as it is about undertaking administrative and constitutional review. Adjudicators, in my opinion, must consider the policy implications of their decisions, focusing on the public regulatory function of international adjudication, both as it exists in international arbitration and international courts, moves away from the traditional conversation about institutional and systemic differences between international courts and international arbitration. And these responses, these internal responses, could play a crucial role in shaping the perception of adjudicators and their mission. Depending on their view of international courts or arbitral tribunals, some adjudicators may put greater weight on the public aspect or the private. They may give due weight to considerations of the international community or only to those of the parties before them. They may contribute to the development of international law, or they may prefer to raise the non-precedential value of their decision. Permit me a few concluding thoughts. Proposals for international courts, such as the EU's Investment Court or the 2000 proposal for a World Court for Human Rights, need to consider the reasons for their initiatives and how much of it stems from what I've referred to as the pull of an oceanic feeling. Are they unwilling prisoners of history? As James Crawford has noted, we must try to achieve a historical understanding of our own activities, for only in such a way we will be able to fully comprehend them and advance beyond them. And this, my friends, does not mean that we should entirely set aside international adjudications past. Rather, we should recognize that a narrative exclusively centered on international courts may not be the best fit with the institutional diversity and innovation required to meet the challenges of an increasingly globalized world. We should not be afraid of seeking complexity in the design of international adjudication, of creating new laboratories that may eventually lead to progress. Perhaps, counterintuitively, we should look for innovation in the first Hague Peace Conference and not in the Treaty of Versailles. There is some evidence that innovative institutional designs arise in moments when the faith in international courts was weak. I think, for example, of the adoption of the ICSID Convention in the backdrop of the ICJ's controversial 1966 decision in the Southwest Africa cases, or the adoption of UNCLOS and its a la carte approach to international adjudication in the backdrop of the ICJ's Nicaragua decision. As Susan Katzenstein wrote recently, crises are moments in which states become receptive to international adjudication proposals, not moments of institutional epiphany that become obsolete once the crisis is over. And perhaps moments of adversity may be the best evidence of the Oceanic feeling. It is during legal crisis, when the pull of the Oceanic feeling towards international courts is the weakest, that the international community should innovate. Merci.
Thank you very much. You've taken from your own experiences and placed what I know for my students of international law and of international adjudication is a very apposite sense of struggle. When I studied international law, there were very few international courts and tribunals. The PCA was dead. ICSID had, half a case. The ICJ had a couple of cases, and there has been a transformation that has taken place, and you've situated that transformation in its historic context and forced us to challenge some of the assumptions that push in competing directions, and for that we are extremely grateful. Thank you so much for taking the time out of a really hugely busy schedule to share with us your thoughts. Your thoughts do come at a very significant moment. You referred to the current effort to negotiate a partnership between Europe and the United States, which includes on investment dispute. Your words come at a moment when probably the single most appalling incident of arbitral lack of independence has demonstrated itself in proceedings in which, as you mentioned, I had the, well, I don't know whether it's privilege or misfortune to be involved in. And you have forced us, from your perspective, to challenge some of our assumptions. So I'd ask everyone once again to thank you warmly for joining us this evening. Thank you very much indeed.